Good afternoon and welcome back. I'm Marcus Peter. The Supreme Court recently heard oral arguments over President Trump's executive order that attempts to end automatic birthright citizenship. Dean John Czarnetzky of the Ave Maria School of Law gives us his analysis. John, so great to speak with you. How are you?
Marcus, I'm doing very well, and it's always a great pleasure to be on your program. Thank you for the invitation.
I always look forward to being able to reconnect with you, and I thank you for your objective astuteness in thinking of matters about the law in society. And this issue is no different. I invite you to share with our listeners the history of birthright citizenship so we have a context of continuing this conversation.
Yes, and thank you. I know that our time is limited, so this birthright citizenship issue comes from the text of the 14th Amendment, which was ratified in 1868 in the wake of the Civil War. Much of the 14th Amendment was concerned with slaves and the status of slaves. Section 1 begins with all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And so the issue that comes down to us, to jump to today and then we'll go back, is the meaning of the phrase subject to the jurisdiction thereof. So let me repeat. All persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. So the almost customary interpretation of that has been, at least in so-called modern times, that if you're born in the United States, you're a citizen of the United States. But that ignores, or to date, let me put it more precisely, the courts have not directly and systematically addressed the meaning of the phrase subject to the jurisdiction thereof. Mm-hmm. And so think about that, Marcus. We've had in, again, modern times, the past century, the past 70 years, we've had thousands and thousands, maybe more, people that are born in the United States, parents from foreign countries, and they've just been routinely assumed, because of this clause, to be citizens of the United States. And President Trump entered an executive order refuting that, saying that essentially, and these are my words summarizing perhaps imperfectly, the executive order says, no, the phrase subject to the jurisdiction thereof means having full and unfettered allegiance to the United States, not simply being in the United States when their child was born. And that is the question on which this Supreme Court case turns. And I, frankly, went to a very fine law school, of which I'm very proud. And the assumption there, and I think for decades, has been, well, if you're born on American soil, you're an American citizen. Well, it turns out that the history is much more complicated, and this was reflected in the Supreme Court arguments.
I'm really glad. Oh, go ahead, please.
No. I wanted to give you a second. It was, and by the way, there is. I usually don't cite things, but there was a superb summary of this in an op-ed piece in the Wall Street Journal just after the argument by a professor named Randy Barnett, who's a well-established scholar at Georgetown Law School. And it does lay out what I'm about to as well. The folks that are arguing for the common understanding argue that the phrase subject to the jurisdiction thereof simply means that you're in the United States and you're subject to the laws of the United States just by being here. So if I'm a foreigner and I run a stop sign, I'm subject to the traffic laws of the state. I mean, that's just very straightforward logic. And that's what their argument rests on, and that's been the common understanding. But it turns out that the history of the 14th Amendment is much more complicated than that, including two cases that are often cited on this issue. And it turns out that in this, whether you credit this or not, depends on your theory of constitutional jurisprudence, turns out that on the floor of the Senate and the House, the drafters were pretty clear that subject to the jurisdiction thereof doesn't mean simply being subject to the laws. It means owing allegiance to the country. So everyone agreed that children of diplomats, children of soldiers from an invading army, and at that time at least, Native Americans who were still members of their tribes, all were excluded. So everyone to this day agrees that those were the categories. But it still leaves open the question, what about parents who are here illegally, who have overstayed their visas, who are not permanent domiciliaries, green card holders is the common term. What about them? And I know I'm speaking a lot here, but I'll give you two quick cases, and then I'm sure you have some questions if we have time. The first case Supreme Court took up on this was a case called Elk versus Wilkins, which simply stated that members of Native American tribes who are still members of their tribes were not subject to the they didn't recognize allegiance to the U.S. Importantly, the court did not hold there that simply being born on American soil is enough. In fact, they adopted this idea that being subject to jurisdiction has to do with allegiance, a word that the justices in the recent case repeated over and over again. And then, very importantly, there's a case called U.S. versus Wong Kim Ark in 1898, cited by both sides. And just to land the plane quickly here, Marcus, because I know your time is limited, there was a child in that case born in the United States, parents of Chinese descent, who at the time of his birth, his parents were subjects of the Emperor of China. And the court in that case did hold that that child was an American citizen because he was born in the United States. However, very importantly, and it was a topic of conversation at the Supreme Court, at that time, the parents were what we would call today permanent domiciliaries of the U.S. They were, at the time it didn't exist, but we would call that today green card holders. And so it's an interesting question. For decades, the assumption has been you're born on American soil, you're a citizen. But the case law does not, that everybody assumes supported that, does not exactly support that case. So what are the justices going to do with it? It's an open question.
You were right. We're just about a minute left in the segment, but I'm very grateful for that very comprehensive presentation of the issue at play here. I have one quick question then. Is there a socio-political benefit to the United States to rethink the scope, therefore, of birthright citizenship?
Socio-political. Well, I'm a person that believes that the only unlimited resource in the world is human talent. And so I'm, in general, pro-immigration. All of us are, in one way or another, almost all of us are the product of immigrants, as I proudly am. On the other hand, I also believe in the rule of law. And birthright citizenship is a problem.
Well, I share that with you. John, thank you very, very much for making the time. My guest has been Dean John Czarnetzky of the Ave Maria School of Law, and he has been sharing with us an analysis of the present case that Donald Trump essentially has brought before the Supreme Court pertaining to birthright citizenship, and we will follow this case closely. Stay tuned, I'm Marcus Peter.